Okay. Let's get started like we always do with a word of prayer. Representative Williams, would you open us with prayer, please? Push a button. There you go.
Let us pray. Almighty, everlasting, and eternal God, we thank you once again for the victory and the day. We ask you, Lord, to be with us as we do the business of the people. Bless each and every one of us. Keep our hearts open. And Lord, bless the chairman for waking us up so early to do rules for it. It's in Jesus' name we pray. Amen.
Well, I think 7:30 next week will work.
I'll really pray for you.
Goodness gracious. Okay. There, just a little FYI, there are a boatload of study committees that have been introduced. For all committee chairs, you can set up a committee or study committee out of your committee. It has to be just in your committee. You can't pull across committee lines. But you can study anything you want to if you pull it up out of your committee. And you don't have to go through this process, because I'm going to kill most of them. Oh, since I was on a roll yesterday, House Bill 189 recommitted back to committee. Okay. Let's see. What's that? Yeah, bring it back on day 29.
We'll have a shorter meeting, Mr. Chairman.
Yeah. Okay. Do we have any committee chairs over there? Yeah, I see one or two. There. Okay. And that's 3 or 4 over there. But we got this good-looking lady over here, but she's going to go first. Representative Hong.
Thank you, Mr. Chair and members of the committee. I present to you House Bill 128. That's LC 365387EC. This bill comes in response to a executive order by Governor Kemp from July of 2022, and it had the Department of Administrative Services look at the state contract procurement for minority-owned businesses, small businesses. And what they found from that report is that the process is confusing. It's not very accessible. So what this bill will do is streamline the state certification process for minority-owned businesses, makes it more efficient, accessible, and essentially what it's doing is it's taking out the federal certification requirement and putting that just through the state certification through the Department of Administrative Services. Currently, if you want a state certification, you have to go through a federal certification, which goes through the Georgia Department of Transportation. So you have companies that are supplying things that has nothing to do with transportation that are having to go through GDOT. But this bill will essentially allow Department of Administrative Services to set guidelines and go through that certification process. In addition, we are adding women-owned and veteran-owned businesses to this process, and so this bill will include women-owned and veteran-owned. As many of you know, we have a vibrant small business community here in Georgia, and we ranked in top 10 for minority-owned, women-owned, and veteran-owned businesses. So this is just making it a lot easier for those businesses. And I will take any questions, Mr. Chair.
Okay. Will Park.
Thank you, Mr. Chairman. Thank you, Representative Hong, for the good bill. I was just wondering, are there any reporting requirements that could provide additional information and track how much state dollars are going to minority, women, and veteran-owned businesses to ensure we're equitably investing taxpayer dollars in all of our communities?
I'm sorry, I'm having a hard time hearing you.
Let me turn up the volume. Go ahead.
Sorry.
Does the bill have any reporting requirements so we can better begin tracking information as to where state dollars are going for minority, women, and veteran-owned businesses?
Correct. So currently that is not being tracked by the Department of Administrative Services, but they are implementing different softwares in order to do that. And I think there are certain softwares that they're going to implement actually for all government agencies in about 2 years. But in the interim, they are having an interim software that's going to be able to track that.
Thank you.
Okay, I don't see any questions.
Thank you, Mr. Chair.
Hold on. 1 second.
Thank you, Mr. Chairman. Just a question I hear about. You hear about this from time to time, ma'am. Is shell companies acting in bad faith and taking advantage of these? And you look in line 201 that the penalties for doing it are very little, and you hear about this in your communities and other places that so and so hired this wife or whatever to be the front person for the shell company that operates under this code section. I'd like to know what we can do to strengthen the penalty to prevent this, or what we can do to make sure that these things don't happen, that this has good faith in what you're trying to do.
Thank you, Mr. Chair, for that. I understand as far as the penalties, but there are, if you look at line 83 on, there are certain eligibility. For example, you have to show that more than 51% of the business is owned by minority women or veterans. You also have to show that those minorities, women, veterans are participating in more than 51% of the operation of the business as well. So DOS is setting guidelines in order to make sure that they receive proof of that.
Thank you, Mr. Chairman. Thank you.
Madam Pro Tem.
So I had a question. So what prevents a couple from just putting it in the female's name to circumvent the intent? Would it same business, essentially same business?
Correct, and I think that they've had issues with that, and that's why they are putting in proof that if it was the spouse that's, or the wife that's not really participating in the business, but they're just putting the business in their name, you have to now show proof, or it has been that way, but they're going to be more stringent upon actually showing proof that you are participating in the operation of the business. And that is a concern that has been brought up, and it has been in the report. And so DOS, in setting their guidelines and showing proof, they're going to be more strict about what kind of proof that they're going to show.
Well, I just want to mention that, I mean, people are smart, and they're going to figure out how to get around it. And I have concerns as to whether it will actually achieve the aim that it desires to, because there's such benefit. There's such incentives to find a workaround just to meet the letter of the law. But thank you.
And I'll bring that concern to DOS. Thank you.
Okay, well, no more questions. Thank you, ma'am.
Thank you, Mr. Chair.
The only one that could have preempted you was next in line there, because I don't want to have to go before the ethics chairman. Mr. Chairman, which bill is yours? What's your number?
Georgia House Bill 294.
Okay, second page. Okay, tell us what it does. Go ahead.
Thank you, Mr. Chairman. It's indeed an honor and a privilege to come before your committee this morning and talk about House Bill 294. This is a bill that gives us guidelines and, in fact, lays out what must happen to a reinsurance contract when the ceding carrier is in liquidation. Over the years, this body has passed much legislation to protect policyholders in this state. This bill deals strictly with companies that write life, disability, long-term care and annuities, and deals with nothing else. And simply what it does is, whoever the successor is in a liquidation, which could be an entity called the Georgia Life and Health Guarantee Association, which was created in 1981 by the General Assembly. It could be the liquidator, which in Georgia would most likely be the insurance commissioner, or it could be what we call an assuming company, and that's normally what happens, where another insurance company agrees to take the responsibilities of the company in liquidation, the responsibility to their policyholders. This bill simply guarantees that any one of those entities that's assuming those responsibilities has the right to continue the reinsurance contract with that reinsurer. If they elect not to continue it, there are provisions here in how the financial affairs are settled between that reinsurer and whoever the assuming company is. It spells out how we figure out who owes whom, and if they cannot agree, then of course there's a long section on arbitration. That's what the bill does, simply, Mr. Chairman.
Okay, well, undoubtedly you did a pretty good job, or they're afraid not to vote against it. You have no questions.
Thank you very much.
All right, thank you. Yes, sir. After you. Hey, y'all can come on up a little further. You know, it's just like on the House floor when they, morning orders. The person who's supposed to speak next is in the back of the room. Okay, go ahead.
Thank you, Mr. Chairman. Members of the committee, House Bill 207, next to last on the front page. This is the DNR annual update. It does two simple things. Last year there were some typos and I think interpretations for our lighting systems on our boats. They feel as if now it is for all vessels, and we need to keep these lighting systems to just coastal vessels, is all it does. The second thing this bill does is we've got right now a loophole in our BUI law. Right now, if you're in a boating accident, even if there's serious injuries or fatalities involved, they have 48 hours. The participant has 48 hours to report that incident. Changing this means they have to stay on scene till law enforcement arrives, and that's all this bill does.
Okay. All right, Wilton Park.
Thank you, Mr. Chairman. I think it's a good bill. The one question I had in just reading it is, on line 60 to 65, I was wondering, why is there no affirmative duty to immediately notify emergency medical services if they find an injured person, and only an affirmative duty to render aid for injured persons on lines 54 to 59?
I can't hear him very well.
Okay.
Are you talking about the amendment?
Speak into the microphone, good.
So on line 60 to 65, there's no affirmative duty to immediately notify emergency medical services if they find an injured person. There's only an affirmative duty to call 911 if they find someone who's deceased or unconscious. So I was wondering if there was just an oversight in which there's no affirmative duty to call 911, but there is an affirmative duty to render aid to an injured person.
It is. That's what we're trying to fix in this bill, is to make sure that this incident is reported right away, and all participants have to stay on scene until law enforcement arrives.
Okay, thank you.
Okay. Speaker Pro Tem.
The author may not know this, but I seem to have recalled a situation. I'm not sure there's an affirmative action to render aid after a car accident. I think there. So I don't. I mean, maybe some of the folks who deal with that area of the law would know, but that may be why it's not extended to this. But I don't know the answer. Check.
Okay. All right. No more questions.
Thanks, sir.
Representative?
Thank you, Mr. Chairman and members of the committee. I have actually 3 bills on the sheet today. The first one is an oldie but a goodie, House Bill 80. Members of the committee may remember my previous appearance with that bill earlier. This would allow you to introduce in a civil case an unnotarized statement that would have the effect of evidence and testimony that could be utilized in the lawsuit when it's a written statement. This is primarily with pretrial motions, preliminary matters that occur in litigation. We've revised the bill so it does not allow the introduction of a written statement if it's signed within the United States. It has to be an overseas or international statement. Part of the reason for having this requirement is it's very difficult to get something notarized if you're giving a written statement overseas. You've got to go to an embassy and schedule an appointment with a consul or vice consul, and that can oftentimes be difficult for people and involves a lot of travel. So we've tried to limit the scope of the bill and thus hope make it more palatable to members of the committee.
Okay, very good. I don't see any questions. What's your next one?
Next one is a little further down that page, about midway of the modified structured rules section. It's House Bill 186. I am aware, Mr. Chairman, of the expression of something as a cleanup bill is often a dirty word around here and indicates something much more nefarious going on, but this is literally what this is. The members of the committee may remember last year the Judicial Council produced, and this House unanimously approved and Senate approved, and it was signed into law, the State and Superior Court Appellate Practice Act. That has to do with appeals from lower courts like magistrate courts and probate courts and even things like zoning bodies to a superior or state court. It simplified that process, tried to make it much clearer, and threw out an old archaic procedure called the petition for writ of certiorari. There were a couple of places in the code that we didn't catch where that term appears, and we're simply changing it to petition for review, which is the new vehicle for making an appeal. And then in Section 1, we're simply adding a provision that is intended to further the policy of the bill, which is to change the process but not change any standards of review or things of that nature. And we're trying to add some language to make it clear with respect to a couple of instances that we're preserving that policy and not doing anything that would conflict with those rules. And it's a Judicial Council bill as well.
All right. Well, I don't see any questions on that. What's number 3?
Third one is the top of the back of the page. It's House Bill 220. This bill has to do with homeowners and condominium owners associations. There was a case issued by the Court of Appeals. It was actually a year before last, but it went through a petition to be heard by the Supreme Court last year, and that was not concluded until last year. There was a ruling that basically before a homeowners association can get an injunction against some violation, that is a court order, they have to utilize legal remedies. That's a fairly standard doctrine in the law, but in the case of an HOA or a condominium owners association, what that means is they basically have to use self-help because most of their covenants give them the right to cure some kind of deficiency themselves. So that would mean effectively they would always be going on property to paint the wall or fix the fence or fix the mailbox before they even did anything else. And we felt like that was not a good result. There have been some instances where people have been shot doing that, and we thought that was also more intrusive to the homeowner. So we have placed provisions in the law which would say they don't have to use self-help before seeking an injunction. And we also added, at the request of the Realtors Association, a notice and right to cure provision. That is, they have to give you some notice and an opportunity to fix it yourself before they can even take you to court. And the reason getting the order is important is because once you have an order, you can get the sheriff to accompany and make sure no one gets hurt, both the homeowner and the person doing the work. And that also affords the homeowner notice and a right to be heard and have a neutral third party assess the reasonableness of the action the HOA is taking. So that's House Bill 220, Mr. Chairman.
Okay. Well, I see no questions. Thank you, sir.
Thank you, members of the committee. Appreciate it, and thank you, Mr. Chairman.
Thank you. All right. Yes, sir. Go ahead.
Yes, sir. Thank you, Mr.
What's
Chairman.
your bill number?
This is House Bill 121. It's the first bill on the front page of the blue sheet.
Currently in the state of Georgia, this bill, first of all, relates to all lakes and navigable waterways in Georgia. Currently, we have what's referred to as a no-wake zone, which is a 100-foot buffer between the shores and docks and moored boats, that sort of thing, where motorized watercraft are only allowed to operate in idle mode to prevent wake to cause shore damage. A more recent problem over the last several years is the popularity of what's referred to as wakeboarding and wake surfing. These are specially designed boats or accessorized boats that are created to sit deeper in the water and generate a large wake or wave behind the boat that is sufficient enough to literally surf on a surfboard beside and behind the boat. These waves, even done within 100 feet of the shore, are causing significant shoreline erosion, dock damage, boat damage, and in many cases personal harm and even death has occurred to this. What this bill does is for a water vessel generating a wave that is capable of being surfed on, it restricts that activity to 200 feet or further from the shore, no closer than 200 feet to the shore.
Goodness. We haven't had anybody with a question yet. Thank you, sir.
Yes, sir. Thank you.
Hold on. All right.
Thank you, Mr. Chairman. Just, of course, we don't know what code section all this is in. Does this in any way affect a private lake?
Only if it is patrolled by the Department of Natural Resources, and if it is larger than 50 acres.
Well, if I have a 65-acre lake, they have the authority to come to there.
Correct.
So would this affect private property?
Yes. The Department of Natural Resources has jurisdiction on private property without warrants. So
yes. Don't you think it'd be, if I have a private lake, 65 acres, it's on my property, and I want to do this, shouldn't I be able to do it?
I would think you should, but currently you should also be able to operate your boat within 100 feet, but that law applies to that point also.
Yeah. Thank you.
Yes, sir.
Chairman Parrish.
I've got a question for you.
Yes, sir. Sorry.
On some of these lakes, obviously there's a lot of open water, and I agree the wakes are destructive to the docks, to the shoreline, and tree line, and everything else. But my question is this: if a boat is proceeding down the lake and it's wide and it becomes narrow, and it would have to be at least 400 yards wide, wouldn't it? Not violate this?
It would have to be 400 feet wide. Now,
400 feet, okay.
Now, the boat could pass through a narrow passage. They would just have to drop down to idle and not be generating that large wake until they get to a wider spot.
I guess a more practical question is, how are you going to enforce this?
This law was actually, or this bill was actually crafted with cooperation of Colonel Bernard with DNR, and in his, to kind of paraphrase his words, it has to be a visual activity. In other words, their rangers are trained to visually recognize when this is occurring, and so if they can see it, they can enforce it.
Chairman Powell.
Thank you, Mr. Chairman. Is it not true that in the case of private property and private lakes, DNR, their purview is the game and fish laws for the biggest part?
Yes.
And for other safety, but to get into the recreational on a private lake that nobody inhabits other than the owner of that lake, then that's not what that they would have purview over somebody that's got their own pond and wants to put one of those boats out there.
I'm sure Chairman Powell knows what he's speaking.
Is it not true that you have not emphasized the amount of danger and the property destruction that these boats have done? Because while those of us who live on the lake, we've always said that alcohol and water doesn't mix except when you're mixing scotch. But water and recreation to these boats has become a devastating issue in a lot of the lakes, like up on Lake Hartwell, to the point that our neighbors in South Carolina enacted that 200-foot rule as a guideline to tell these folks, keep those boats out of the coves that are doing so much destruction when it's creating wakes of 4 and 5 feet.
The chairman definitely knows of what he speaks. This bill will put Georgia's limitations or restrictions in line with particularly South Carolina and Tennessee, which we share Lake Hartwell, several other significant lakes, Chattooga, Blue Ridge, and that sort of thing with. Currently, you have one regulation on the Georgia side, and you have a more restrictive, similar regulation to this on the neighboring state side.
Well, Burchett.
Thank you, Mr. Chairman. Isn't it true that we trust our DNR agents with a large range of discretion?
Yes, sir.
So they have the discretion currently to say you're creating a wake within 100 foot of the dock, and it's already prohibited. Is that correct?
That is correct.
Isn't it also true that this protects personal property rights for someone that owns a piece of property on the lake who has spent a significant amount of money improving their dock and their shoreline to the point where these boats are coming by and creating, wave pool-like wakes and destroying their personal property? Isn't it true we're protecting personal property?
That is true, and I would add to that personal safety. This type of activity, the waves generated from this, have taken people out of boats, have knocked people off of docks, and in a few cases actually caused death of small children.
Very good. And my last is, isn't it true that you've got a consensus with the Georgia Lake Caucus in the General Assembly on this bill?
That is pretty much true. Yes, sir. We didn't catch every lake, but most of the representatives who represent areas that have significant lakes were very eager and actually asking to sign the bill. Yes, sir.
Well, very good. Thank you for bringing the bill.
Thank you.
All right, I don't see any more questions. Thank you, sir.
Thank you, sir.
Now, it's really bad when you get a text message or email or something, and the picture that you look at causes you to lose sleep.
Hold on now. It was late. What picture did I send you, Mr. Chairman?
Oh, no, you don't need to see that picture. The thing was, it happens to be my sister-in-law, but then there was somebody else in the picture.
She's
Scary.
wonderful.
Go ahead, Mr. Montahan.
Well, thank you, Mr. Chairman,
Okay.
and members of the House Rules Committee. It is a blessing to be here this morning to present a little bill. And so today I bring to you House Bill 167. Right now, under state law, a license suspension for non-payment of child support leads to what is called a hard suspension. And under a hard suspension, there is no way legally to obtain a driving permit for any reason whatsoever. This includes for the offender to be able to drive to and from work. In House Bill 167, this would give a judge and the Department of Human Resources discretion to give the offender a work permit to drive to and from work with the intent that the offender can stay gainfully employed and pay the child support that is in arrears. Well, that, Mr. Chairman, is House Bill 167.
Is there anything listed in there that you may have mentioned this, but I'm still getting over the shock of the picture, but is there anything listed in here that they have to go through some form of training?
No, sir. So this would be totally up to the judge's discretion. So this is between the Department of Human Resources and the judge who is adjudicating this case.
The driver services supporting this?
Yeah, Georgia Department of Driver Services and DHR in agreement that this bill should move.
Okay. I see no more questions. Thank you, sir.
All right. Thank you, Mr. Chairman.
I met this young man's wife the other day. He really caught her in an awkward moment because if she'd have looked at him, she would have just kept right on going. But his wife is from Columbus, and I know her. I know her family. But everybody makes a mistake every now and then.
She had a lapse of judgment.
Lapse of judgment.
She had a lapse of judgment.
Mr. Gamble.
Yeah, thank you, Mr. Chairman.
And he does have some pretty children, too. Fortunately, they all look like Mom.
They do. They do. And she is the best representative in our house. I know
And
that.
she, hey, at one time, she was a state representative.
Yeah. So.
And a good one. It's gone downhill since, hasn't it? All right, Mr. Gamble, go ahead.
Well, thank you, Mr. Chairman, members of the committee. I'm on the back page, halfway down, House Bill 279. This is a bill that deals with what's considered fortified construction, and it encourages people to build to this fortified standard. Basically, you can accomplish this through a host of materials. You could do it with concrete, you could do it with wood, so it's not specific to a material. It's a completely voluntary initiative where if you built a home or a commercial property to a designated fortified standard, then the insurance companies would decide on their own what type of an incentive to offer you for building to a fortified standard. Again, it's completely voluntary. The concept is that if you build a structure to this fortified standard, it is going to be more resistant to tornado and hurricane and winds and all the different things that a property will incur. This bill passed the House last year 174-0. It made it through committee in the Senate, and we got it out of rules in the Senate, and it made it all the way to the floor on sine die, and it was one of the, I think, 50 or 60 that didn't quite make it across the finish line last year. So that is what the bill is. The insurance industry is good with it. The Commissioner's Office is good with it, and that's House Bill 279.
Mr. Williams.
Thank you, Mr. Chairman. To the gentleman.
Yes, sir.
Sounds like a good bill, but my question is does the insurance industry now reward you for going that extra step? I'm just trying to figure out what this bill does that is not being done.
Right. So right now in other states, this legislation has been approved, and to answer your question specifically, no, they don't, and this would place more emphasis on them doing that. And again, it minimizes the damage, it makes these properties more resilient to the winds and all the different things that may occur on any given day.
Representative Williams.
Thank you, Mr. Chairman. So you mentioned wind. Would this bill not, in fact, be very helpful for coastal property exposure?
It would, and in areas where insurers have pulled out because of the increased risk, this would also help possibly bring an insurer back into that market if a property had been built to the fortified standard. And also, there's a specialty training that an inspector receives to give this fortified standard. You don't just call a regular home inspector out to come and do this, and there's very specific things that the property has to meet in order to be classified fortified.
Whip Burchett.
Thank you, Mr. Chairman. Thanks for bringing a bill, Representative. The question I have is, currently under the state minimum standards, isn't it true that depending on what wind zone you're in, you have to build to these significant standards? Like if you're on the coast, you got to put straps over the top plate of your house. And if with those standards already in place, would they be considered fortified?
Not necessarily, and this is kind of a step beyond what you're going to see in most local building codes in a scenario like that. We went to a property in Floyd County that had been built to a fortified standard where the walls and the ceiling of the home were basically poured concrete. It was amazing because while we were there, standing inside the home and traffic's going by on the outside, you couldn't hear the traffic. But that area has a propensity to tornadoes, and so this is a step beyond what you're going to see most likely in the building codes that are in those areas. It goes a little bit further.
Very good. Thank you.
All right. I don't see any more questions. Thank you, sir. All right.
I have one more.
Okay, go ahead.
I'm sorry.
What,
Yep.
280, isn't
Yep.
it?
Yes, sir. House Bill 280, right there underneath it. This is a model National Association of Insurance Commissioners bill. There was a similar bill that we passed last year that allowed a property and casualty agent to offer a smoke detector, a water leak sensor in the sale of a policy. The idea there is that if you have those technologies in a property, it may potentially help you reduce or minimize exposure. What this bill does is it allows a life or health agent to offer a Fitbit or a blood pressure cuff in the sale of life or health insurance. The insurance company is not going to be keeping any of the data collected on the Fitbit to determine premiums of any kind. It's completely voluntary, but they can do it. Right now it's prohibited under law. It's considered an inducement, which is illegal. This would allow it, and it is also tied to, it cannot exceed the premium for the policy, so it has to be within a certain reasonable range for the cost of these products. The insurance commissioner regulates this, and they support this legislation as well. So that's House Bill 280.
Okay. I see no questions. Is that the last one?
Thank you. Yes, sir.
Okay, thank you, sir. Okay, Chairlady Smith, I think you have something to present. Hold on a second. Now I got you.
It's on. Okay. Good morning. If you look under Modified Open, House Bill 243, this is the second in the list of the judges, Superior Court judges who have cleared all the process and are eligible for a new judge. That's my circuit, Coweta County Circuit, and this is the request for the 8th judge. All money and everything has been vetted and approved.
Okay. All right, no questions. Who's next? Chairman Hitchens, okay.
Under Modified Open Rule, the second bill, House Bill 242, this is a rehash of a bill that, like the previous presenter went all the way through last year. It was number 2 on the docket when the Lieutenant Governor decided to give his go on a way speech, and it didn't get heard. But it's Joshua's Law. It was enacted in 2005. It took 5% of traffic fine money to provide for scholarships for driver training in 3 tiers. Number 1 was for those children of law enforcement officers, military personnel, and firemen who were killed in the line of duty. Number 2 was based on income, and number 3 was open to all others. It never ever, there's such a demand, it's never gone to number 3. In Georgia now, we have a disproportionate number of our young people killed in traffic accidents. In the last 2 years, we're up to about 1,800 a year that die in traffic accidents. Statistical information shows that those children who go through this program are less likely to be injured, killed, or involved in an accident, and less likely to get citations. The money is still being collected, but as I think you remember, it expired last June 30th. Governor's Office of Highway Safety is not getting that money, but there's over $1 million in the fund right now.
Okay. I think that these lights that are blinking have bills to present. I don't see any questions. Thank you, sir. All right, well, since we're on this side, Chairman Lumsden.
Mr. Chairman, members of the committee, I have 2 bills. House Bill 221, which is on page 2 under modified structure, LC number 5200264S. This is a department bill that comes as a request from the insurance commissioner. It deals with rate filings for auto insurance. This bill keeps the current file and use model in place for the state mandated minimum filings and adds a 60-day waiting period for all other filings. This is a compromise bill that all affected parties have agreed to. It provides adequate time for the department to review the filing, and it provides a guarantee of speed to market for the insurer. That's the bill.
Okay, I don't see any questions. You got another one?
Yes, sir. Same back of the page, House Bill 222. It is also an insurance commissioner's bill, LC 520208. This is a bill that clarifies the insurance department's practice in 4 areas of the insurance code. The first change adds language that makes it clear that the insurance department only regulates service contracts that are sold to consumers, not to any other entity. The second change deals with a probationary insurance license and extends the period of a probationary license from 12 months to 24 months. The third change deals with the reapplication for an insurance license when the license application is denied. This allows the commissioner to let applicants reapply between 1 and 5 years after refusal. Right now, they have to wait 5 years, and since some license refusals and revocations are less serious than others, this gives the commissioner some discretion. And the fourth change simply removes a reference to a code section that no longer exists. That's the bill. Appreciate you.
Okay. Well, I don't see any questions.
Thank you.
All right. Chairlady Taylor.
Thank you, Mr. Chairman. I have two bills for you. The first one is House Bill 315. It's on the back, second from the bottom. I'm working off of LC 520242. This has to do with a bill we actually have passed before. It has to do with mammograms, and when an additional screening is necessary, we want to make sure that the insurance companies pay them at the preventive level. And in the past, we had it listed as a certain guideline to use, and it limited it to just the one January 1st, 2022. This gives the commissioner the authority to use new regulations when they come out. It gives it, him the rulemaking. That's all the bill does.
Okay, I see no questions. Yes, ma'am.
Thank you. The next bill is House Bill 317, LC 432612. This is a bill that we passed last year. It went over to the Senate and didn't get through. It has to do with funeral services. Right now, our state retiree employees don't have the authority for their beneficiaries to assign the benefits to the funeral home, and we have retirees, once they pass away, their beneficiaries get the money and are not coming back. This is what any other insurance company has the right to do, is let the beneficiary determine if they want to assign those benefits. I do have a fiscal note, and it does not have any, it's a non-fiscal retirement bill. It does not affect it. The retiree program is, their only concern was, oh, could somebody else come in the future and want to do it? Well, this is just strictly for funeral homes only. It's very limited, and it is up to the discretion of the beneficiary. That's what the bill does.
Okay, very good. I see no questions. Thank you, ma'am. Chairman Dempsey, Chairlady Dempsey, excuse me.
Good morning. Thank you, Mr. Chairman. Yes, the bill I have before you today is House Bill 213. It allows, this is only an update to a measure that passed in 2009, which if a local school board of education provides information, there's very specific information about vaccines that should be included. It allows but does not require. It does not mandate. The original measure did not either. Vaccines for these or any other illnesses or diseases. The age has changed from 6th grade to kindergarten for the information to be provided for influenza. So that is basically all that it does. It's very specific. You'll see it on line 25 through 28, what should be sent out to parents and guardians to allow them to use their own best judgment to make decisions about vaccines for their own child.
Okay, got a question for you. Vice Chair Ballinger.
Thank you, Mr. Chairman. Chair Lady Dempsey, I have gotten 136 emails about this bill since 10 o'clock last night to 9 o'clock this morning from constituents. They're all encouraging me to vote no on this because it doesn't require full disclosure about immunization requirements. Now, I know there's nothing in law that prevents local boards of education from full disclosure, but there's no requirement in 213 for full disclosure. Can you explain to me why there's no requirement in 213 to mandate full disclosure?
Yes, I certainly can. It is already in law that is required. The information is already there that no one can mandate that a shot be taken. So I think the concern, because my office did receive some too right before the committee hearing, and it's I would say information that is not full in what they are receiving.
So it's already required. I'm sorry, can I follow up?
Yes, ma'am.
Sure.
So it's already required in law that there be full disclosure?
Let me, I'm
Because that's opposite to what my school board said and all the emails that I've been getting.
So let me make sure I understand your question too. If you would state it again, full disclosure about
The immunization and the exemption from immunizations.
So in OCGA section 20-2-771E, it provides that a parent may object on religious grounds to laws or rules mandating vaccines for school children. That law is already in effect.
Yes, but there's no requirement for our local school boards to disclose that to the parents.
To disclose that no one should mandate it? Well, I don't think that's specifically what this is directed toward. This is directed toward disseminating information about the vaccines, the simple flu vaccine by itself, but not telling anyone they must take it.
But they're not telling anybody that they don't have to take it. Do you see what I'm getting at?
I do. I think it's a twist and a turn kind of what the information is.
Mm-hmm.
It would be putting something else completely different on them that does not parallel what the 2009 legislation that's already there does.
Oh, thank you.
I'm open to conversation.
Yeah, why don't y'all talk about it offline?
Definitely.
Chairman Martin, do you have a question?
If this is enabling, Mr. Chairman, I'll get with the lady after the meeting. But let's do that.
All right, Chairlady Cooper.
Thank you, Mr. Chairman. I bring to the committee House Bill 226. This bill passed the House last year, and there was some misinformation between the department and what the governor wanted. The money was already in the budget to cover this, and they seemed to think they were told there was no need for a bill. It got to the governor, and the governor said, "Where's the bill?" This is about the HIV. Currently, we only cover people that are eligible for Medicaid that have active AIDS. That costs about $30,000 a year if there's no hospitalizations because of complications. People with HIV that are eligible for Medicaid don't go on our Medicaid program, and this bill would move them to our Medicaid program so that they could get better physical care. We have a great number of older people with HIV, with comorbidities, and that sets up a scenario to hurt their immune system and also increase their chances in going into a full-blown case of AIDS, which would cost the state way more, 3 times what it costs if we keep them in good health and they don't go from just being HIV positive to being AIDS positive.
Okay, I see no questions. Thank you. All right, I guess this way we can get Mr. Williams to his next committee meeting. We'll go ahead and set the calendar for Tuesday, February 21st, day 21. Day 21. Okay, under modified open. I hear a move on House Bill 242. Got a move and a second. All in favor say aye. All opposed, like sign. It's on. House Bill 243. Do I hear a move? Got a move and a second. All in favor say aye. All opposed, like sign. House Bill 80. Do I hear a move? Got a move and a second. All in favor say aye. All opposed, like sign. It's on. House Bill 186. Do I hear a move? Got a move and a second. All in favor say aye. All opposed, like sign. It's on. House Bill 221. Do I hear a move? Got a move and a second. All in favor say aye. All opposed, like sign. It's on. House Bill 279, do I hear a move? Move. Got a move and a second. All in favor say aye. Aye. All opposed, like sign. It's on. House Bill 280, do I hear a move? Move. Got a move and a second. All in favor say aye. Aye. All opposed, like sign. Do I hear a move on House Bill 294? Move. Got a move and a second. All in favor say aye. Aye. All opposed, like sign. It's on. House Bill 315, do I hear a move? Move. Got a move and a second. All in favor say aye. Aye. All opposed, like sign. Okay, if you'll notice, there's a few more bills on the calendar than normal. It's going to get worse. I think we had, how many bills we have out yesterday? 17? 17. We had 17 bills passed out of committee yesterday. And we're having committee meetings all this morning. So days are going to start getting longer. Y'all have a good day, and I'll see you at 1 o'clock.